In this chapter, we'll talk about the judiciary and the important role that it plays in Americans' governmental and political process. The decisions of judges based on prevailing customs have formed a body of rules that we know as common law. The system originated in England, later adopted by the colonies, creating a legal foundation that thrives in the U.S. still today. Deciding on new cases by referencing previous ones, called precedent, is now a cornerstone of our judicial system. It relies on the doctrine of stare decisis, which means to stand on decided cases. That obligates judges to follow previous decisions, particularly those made by the U.S. Supreme Court. American law includes federal and state constitutions, legislative statutes, administrative law, and case law. A constitution outlines the structure, powers, and limits of government. A law in violation of the U.S. Constitution, which is the supreme law of the land, may be declared unconstitutional and no longer enforceable. Statutes are laws made by legislatures, increasingly important in delineating the rights and responsibilities of individuals, and they can be created by bodies at all levels. Federal statutes, state statutes, cities, counties, and other local units pass statutes called ordinances, and administrative agencies issue rules and regulations. The way that courts interpret legal issues and make decisions form a far-reaching body of law, collectively referred to as case law. The United States has a dual court system comprising both federal and state courts. Two elements must be present before a case can be brought to court jurisdiction, to the court: jurisdiction and standing to sue. The Constitution gives federal courts jurisdiction, or the authority to hear and decide cases, that is limited to two types of cases. They hear cases that involve a federal question, that's an issue based on the U.S. Constitution, a treaty, or federal law, and they also hear cases that involve diversity of citizenship. To justify a lawsuit, the party must have sufficient stake in the matter, suffering harm, or being in danger of doing so, called standing to sue. Standing to sue is if a party has sufficient stake in the matter, suffering harm, or being in danger of doing so. The issue must also be a justiciable controversy, one that is real and not hypothetical. The courts do not advise on hypothetical questions. A number of concepts define the nature of lawsuits. The plaintiff is the person or persons or organization that initiates a lawsuit, while the defendant is the person, persons, or organization against whom a lawsuit is brought. In recent decades, interest groups litigate most cases involving discriminatory actions, virtually all involving civil liberties, and many involving business matters. They usually file a friend of the court brief. The friend of the court brief is a document calling for a desired outcome in a case filed by an interested party. Individuals or interest groups may also bring a class action suit, one that seeks damages for all persons similarly situated. Both parties must comply with procedural rules, which keep the process orderly and fair, protect their rights and interests, identify the issues at hand, and set procedures for the jury and trial. If a party does not follow the judge's rules, the court can cite that person for contempt. Civil contempt involves ignoring or defying a court's order to benefit another party. Criminal contempt involves obstructing justice or disrespecting the court. Federal court system is a three-tiered model. 3 tiers: district courts, appeals courts, and the Supreme Court. District courts are trial courts. That's where most cases begin and testimony is taken. They have general jurisdiction, meaning that they can hear a broad array of issues. Courts on the lower tiers have limited jurisdiction, meaning that they can hear only certain types of claims. Each state has at least one federal district court, and the nation now has 94 federal judicial districts. There are 13 courts of appeals, also called U.S. Circuit Courts of Appeals. 12 of them hear appeals directly There are 12 of them hear appeals from federal courts in their geographic area. The Court of Appeals for the 13th Circuit, the Federal Circuit, has national jurisdiction over certain cases. These courts do not retry cases. Instead, their panel of judges decides whether a lower court made a mistake, usually based on questions of law rather than questions of fact. Their decisions are almost always final, except in the rare instance when the U.S. Supreme Court agrees to review the case. The highest level of the three-tiered model is taken up by the U.S. Supreme Court. It can exercise original jurisdiction, acting as a trial court in cases where foreign diplomats or states are parties, but it usually reviews cases, acting as an appellate court. It can review state Supreme Court decisions, but only if a federal question is involved. Beyond the federal court system, the executive branch may employ administrative law judges who resolve disputes arising from various roles governing federal agencies. Here you see the federal court system with the Supreme Court, the courts of appeals, and the district courts. U.S. government's attempts to combat terrorism have relied on the decisions of specialized courts that meet in secret. America's first secret court was created under the Foreign Intelligence Surveillance Act of 1978. It issues warrants in cases of suspected spies without having to justify these actions to suspects or the public. It has approved virtually every request received. After the terrorist attacks on September 11, 2001, Bush administration extended this court's powers beyond surveillance of foreign intelligence gathering, allowing it to issue warrants for evidence in criminal trials. In response to the 1995 Oklahoma City bombing, the Anti-Terrorism and Effective Death Penalty Act of 1996 created an alien removal court to hear evidence against suspected alien terrorists. And that court decides on probable cause for deportation. After the 9/11 attacks, the U.S. military began holding hundreds of suspected terrorists at Guantanamo Bay. The Bush administration classified them as enemy combatants who could be held indefinitely and were not protected by international laws for prisoners of war. This controversial treatment was ruled as unconstitutional in both 2004 and 2006 by the Supreme Court. In response, the Military Commissions Act of 2006 banned federal courts from taking cases by enemy combatants based on habeas corpus. The Supreme Court's term extends from the first Monday in October through June or July. 9 justices decide which cases to accept, schedule oral arguments, read legal briefs, meet for discussion, and write drafts and final opinions. The court rules on all sorts of issues: free speech, right to religious freedom, right to bear arms, rights of criminal suspects. The court reviews only a small number of cases, but they greatly impact American lives, and the court wields great power just by deciding which cases to hear and which to decline. Which cases reach the Supreme Court? There's no absolute right of appeal to the Supreme Court. It has total discretion to accept or reject any case it is asked to review without explanation. So certain conditions will increase the chance that a case will be heard. 1, when lower courts are in disagreement. 2, when a lower court's ruling conflicts with an existing Supreme Court ruling. 3, when a case has broad significance. And 4, when the Solicitor General asks for review of a case related to the President's policies. The court accepts a case by granting a writ of certiorari, which requests the record from a lower court. At least 4 justices must agree that it is a case worthy of the court's attention. That's the rule of 4. Only a small percentage of petitions are granted, as we mentioned. The justices conduct extensive research based on abstracts, legal briefs, and court records. Rarely is evidence heard. Both parties present oral arguments and are questioned by the justices. All discussions and votes are conducted in private. The court's opinion is its formal statement of decision, including its reasoning related to the applicable law. The lower court's ruling can be affirmed, it's allowed to stand as valid, it can be reversed, voided due to error or irregularity, or remanded, sent back for a new trial. If all 9 justices agree, their unanimous opinion defines this single view. If they are divided, a majority opinion reflects the views of most judges. A concurring opinion supports this ruling, but makes another point or argument. A dissenting opinion disagrees with the ruling, creating a foundation for reversal arguments in the future. The court announces its decisions from the bench. It's released by the clerk and published in the United States Reports. Some analysts argue that the court reviews too few cases, thus giving lower courts insufficient guidance. The number of signed opinions issued each term has dropped significantly since the 1980s. The Constitution authorizes the President to appoint Supreme Court justices with Senate approval. Congress appoints federal judges with Senate approval. So the presidents and senators are ultimately responsible for filling more than 840 federal judgeships, all lifetime positions. Based on outside recommendations or personal views, the president nominates a candidate for a federal judgeship and then waits for confirmation or rejection via the Senate Judiciary Committee. Until President Carter's restructuring, the nomination of federal district court justice originated with a senator or senators of the president's party from the state in which there was a vacancy. This treated judicial appointments as a form of patronage. And since the Reagan administration repeal of Carter's Act, the president has had complete control over nominations. Senatorial courtesy allows senators to veto a judicial appointment in their state, acting as a constraint on the president's freedom to appoint judges. The opposition party has also been given senatorial courtesy, though it was denied of Democrats in 2000. Candidates for the courts of appeals are scrutinized more closely since they are fewer in number and thus more influential. These positions are often seen as stepping stones to the Supreme Court.